Yes. Hello, my beautiful friends, and welcome back. I hope your week has been outstanding. We have a tremendous show planned here tonight. We've got some big wins today. One out of the executive order entire conundrum that the left finds themselves in. Of course, the president issuing a big executive order saying that they were going to do a couple of things. One, create a list that the states could tap into to validate their voter rolls. We know how important these lists are and how much they are fighting to prevent the DOJ from getting their hands on them. And the other was about the mail-in ballots and whether or not the U.S. Postal Service could put their hands in and validate the mail-in ballots, because we don't want the federal government to be facilitating fraud, in this case in the form of absentee and mail-in votes. So all of that was battling around. And now we have another decision from Judge Carroll Nichols out of D.C. We're going to take a look at it. Not too long of a decision, but we'll hit the highlights. It's brought by the Democrat Senate Committee, by the League of United Latin American Citizens, and by the NAACP. And so they just suffered a big loss today. We're excited to get into that one. Then we've got updates on E. Jean Carroll, the lady who says that she got Bergdorfed in a dressing room at Bergdorf's and had a hard time really pinpointing the year on when that all went down. And then, of course, the jury came down. It was a civil case, not a criminal case at all, and didn't believe her. Said that there was maybe a little hand contact, but there was no R-ing that occurred. They found her not to be credible on that and said that there was, in fact, no Bergdorfing going on at all. Well, as we've covered here for a long time, that entire lawsuit was funded by a guy called Reid Hoffman. And E. Jean kind of lied about where that money came from. And that could have been very relevant to the finding and been pertinent to the jury's evidence when they were making their decision. But they didn't hear much about that. And now the DOJ launching a criminal investigation into her. And we're going to explain exactly what's going on, refresh our recollection a little bit, and see what else is going on with some of the other Trump attackers. Letitia James back in the news, along with Alvin Bragg, who was, of course, responsible for prosecuting the president for those 34 felonies that weren't really felonies. They kind of made that up, too. All coming up here in just a few. And then we've got the Somali fraud situation that continues to develop. We've now got two ladies who got arrested and indicted for $21+ million in Somali fraud. Good news on that, and some follow-up to that ICE story in Newark, New Jersey, where they continue to attack the federal facility, and Mark Wayne Mullen has some ideas on what to do about it. So we're going to have a beautiful stream here together. Thank you for joining us. Thank you for subscribing, liking the video, and all of the things. And we're confirming the tubes are working before we jump on into the business that we need to attend to today. And it looks like we're coming through loud and clear. Tremendous news. That's great news. So we can go ahead and get started. And so let's do it, shall we? Right now. Big victory over the Trump election executive order. We know that this was a big problem for the Democrats. And when Trump came out of that Oval Office and said, we're going to be fixing our broken elections, there was a meltdown all across the country. And in one lawsuit, we saw 3 different groups filed lawsuits against the president in his personal capacity, against the executive office of the president. And these entities here we see are the NAACP. We've got the League of United Latin American Citizens, and the Democrat Senatorial Congressional Committee, the DSCC, whatever it stands for, all came out of the woodwork and said, don't you dare fix our elections. We survive on the fraud. And this is going to be a big problem for us if you get this whole thing solved. And so a new decision just dropped today, courtesy of this judge, Carroll J. Nichols. And he's been a little bit squirrely. We've seen some problematic decisions from him before. He is a Trump appointee. And Just the News has the headline for us now saying, Judge clears Trump's voter citizenship checks and mail-in voting crackdown, slapping down the Democrats. Boy, that sounds good. And so we got the full decision here queued up. But the judge is Carroll Nichols, as we mentioned. The Democrats came pouring in. They wanted a preliminary injunction, which is to stop the executive order from having any force and effect, from having the executive office of the presidency or the executive branch in general develop the policies, make the rule changes, and more. And it's a 26-pager. We're going to hit the highlights of it, but lots of quotes here. And so let's just jump right in, shall we? We recall that this judge was appointed by President Trump in 2019. He was also on the FISA court, or has been on the FISA court since 2024. He's had some notable decisions in the Steve Bannon case, the Capitol attack case is what they call it, Dominion, and many other matters, because he, of course, is in Washington, D.C., where this decision is originating. And here is what he decided in a big, big victory. He said, all right, rewind the clock. Remember the glorious day of March 31, 2026, when President Trump came out and he said, boom, Executive Order 14399 is now going to ensure citizenship verification and integrity in federal elections. And Democrats across the country got down on their knees and screeched like that crazy lady in that video. It says the goal is to prevent violations of federal criminal law and maintain public confidence in elections. So all of the leftists sued, and these cases were consolidated here. They wanted an injunction specifically over two key parts of the executive order. The first is Section 3A. It directs the Postal Service, we're talking mail-in balloting, to issue within 60 days notice of proposed rulemaking that would require mail-in ballots for federal elections to conform to certain design requirements. It's like certified mail. We're going to increase some of the tracking and the verification so that we are not enabling fraud that's passing through the Postal Service. We're going to have a unique intelligent mail barcode and designated markings that would include a process for individuals to be enrolled on a state-specific mail-in and absentee participation list. And just to be clear, this is not ordering it to happen at the moment. It's a notice of proposed rulemaking. Okay, so it's saying, I am now authorizing these agencies to spend some time and some money and some effort to go in and make a proposal. And then we'll debate the proposals, and those proposals will have periods for objections and discussion and more. And right now, that's not where we're at. It's early. The order also directs that the Postal Service must issue a final rule within 120 days. But the Postal Service, he says, has not issued a notice of proposed rulemaking. We don't even have a proposal or responded to comments that it might receive, let alone adopted a final rule. We're just talking about it. Now, until then, that happens. Right now, their claims are not ripe. There's nothing to complain about. They cannot establish that they would suffer harm because there is no final rule, not even a proposed rule, that is both imminent and causing irreparable harm. Now, as the Court of Appeals has put it, the issuance of a notice of proposed rulemaking, just like, well, we think we're going to do this and we're going to contemplate some methodologies to get this done, that alone often will not be ripe for review. So they haven't done it yet. And so what are you complaining about? Well, we don't even want them to think about it. Well, that's not how that works. How can you have irreparable harm and damage that's imminent if nothing has even happened yet? Are we not allowed to think about things and debate things? Now, the second provision that they melted down over directs the Secretary of Homeland Security in coordination with Social Security to compile and transmit to each state, and it's all about the lists, a list of individuals in that state who are confirmed to be in the United States as citizens and who will be above the age of 18 during the upcoming election, and who live in that state as well. Now, the order also directs the Secretary of Homeland Security to, quote, establish infrastructure, compile, maintain, and transmit the lists, and develop procedures that allow individuals to access and, if necessary, update and correct their personal records ahead of the elections, which they do not want to happen. Harmeet Dillon is suing in like half the states at the current moment, asking to see those lists under federal law. actually saying she's got a right to do that because the law empowers the attorney general to do that. These are state elections, but they're sending representatives to the federal government, and the federal government wants to ensure that the people coming to them are not perverted by California lists. And they know that this is so damning to them that they have spent every single effort that they possibly can muster to stop those lists from being transmitted and revealed. But again, the order does not mandate anything. No action by a state once a list has been transmitted to it. So the feds can create a list and give it to the states. And remember, the red states want the lists. They're saying, sure, that will be very helpful to us. We'll then be able to cross-reference our list with your list and make sure that the bad hombres who are not supposed to be on the list are not on the list. But the blues don't want that to happen at all. He says, in any event, no infrastructure for compilation or transmission of the list has been established. No list has been created or transmitted, and no state has taken any action with respect to any list anyways. And they're so mad they don't even want a competing list. In these circumstances, they have failed to show that they're likely to have any standing at all, or that they will suffer imminent or irreparable harm absent an injunction. And so the court recognizes that the Postal Service may ultimately issue a final rule that does affect them, or the government may develop a state citizenship list that omits certain individuals because of flaws in the list making, and then they can come back and renew their motions if and when those future actions occur. And so until then, however, they cannot show that any injunction is warranted. We're allowed to debate and contemplate these changes. More background on this, of course, we know when the order came out and more about it. The litigation is about those two sections we just talked about. Section 2A of the order says that citizenship lists shall be updated and transmitted. They don't have to do anything with them to state election officials no fewer than 60 days before each scheduled federal election. And they can cross-reference them, saying that the Homeland Security, now Mark Wayne Mullen, will be establishing within 90 days the infrastructure to develop those lists. And it's the feds. They know who are citizens and who are not. And the states can check the list. The feds are making a list. The states can check it twice to find out who should be notified and sent to ICE. The order does not mandate any state take action on this once they get the list. And at this time, there are no lists. No infrastructure has been created at all. And so this is kind of like a double-edged sword. First of all, the Democrats lose this, but we also don't have any lists that are made. We don't have any infrastructure that's now been built out to actually use. So are they going to get this done before the midterms? We'll see. But it's a victory that's kind of fleeting because he's like, well, there's really nothing happening. So I really can't find in your favor because they haven't done anything yet. So, well, we want them to do something. And when they do something, they'll have to come back. Now, second, Section 3 directs the United States Postal Service to initiate rulemaking. This is also going to be a big one, and I'm very excited to see how this ultimately fleshes out. In particular, the order requires the Postal Service to issue within 60 days a notice of proposed rulemaking that at minimum would require mail-in ballots for federal elections to have certain design requirements like an intelligent mail barcode and designated markings, and to develop a process for individuals to be enrolled in state-specific mail and absentee lists. The order, because the Postal Service is a federal entity, right? That's governed under the presidency. It's got its own body. It's kind of governance board, and it's all tucked away under the executive branch. So Trump is saying we have authority to change these things. The states want to do mail-in ballots, that's fine. But the Postal Service is going to be picking them up and delivering them, and we are not going to be facilitating fraud in the collection of these ballots. Now, like Section 2, Section 3 also says the preparation and transmission of each state-specific mail-in and list shall comply with the Privacy Act. And at this time, there are no rulemaking efforts that have even been done. So in the 3 days following this, they sued instantly, right? They all came out. We've seen this all over the country. I think they're also suing in Maryland. The League of United Latin American Citizens versus the Executive Office of the President, United Latin American Citizens. Are you sure? Yeah, I'm sure they're Latin. Are they really American? And are they really citizens? Yeah. But although the complaints were filed by differently situated plaintiffs, they have different particulars. Together, they're all challenging this. They're all saying this is illegal. Trump can't do this. It's ultra-virus. Saying it violates the separation of powers, First and Fifth Amendments, due process, and is inconsistent with the APA, various laws related to the Postal Service, and the Voting Rights Act. Their rights are being violated by having to prove some citizenship here. And that's not even what's being requested. It's just saying to the states, we'll give you the list. Then if you are still sending people ballots who should not be getting ballots, now you're on notice, okay? Now we sent you a list, and on that list were not all of these people who should not be getting the ballots. So maybe that will lead to further repercussions. But they don't even want that because ignorance is their biggest defense. It's their biggest excuse. How many cases have we covered here in Fanny Land, Fulton County, where we ask, why are there duplicate and triplicate ballots? Why are there no sign-offs on the entry and exit records before the election and after the election? The tabulator tapes. Why are data cards pulled out of one machine and then inserted into another machine? Why are all these seals broken? Always ignorance and incompetence, one or the other. Never intentionality, never a conspiracy, never duplicity, always just our employees are dumb. It's oversight. It's administrative error. So if you start to batten down the hatches and you start to show them, well, here's where some problems are happening, then they no longer have that gray area. They can no longer say, well, we tried our best with the list. Say, you could have just simply checked against this list, and they don't want that. So they say the president, Trump, is exceeding his authority. He's directing agencies to commit voter registration and mail-in ballot changes that all conflict with federal laws. They say it's going to disrupt us. It's going to harm voters, candidates, and organizations. And those are sufficient to stop them from even thinking about it. They haven't done it yet. They can't even think about it. So the court granted the motions. Now the states are intervening. And so we heard oral arguments back on May 14th. Now we've got a decision. Now we know the standards of a preliminary injunction. It's preliminary. And so there's certain things they have to show. One, that they're likely to succeed. Two, they're going to suffer irreparable harm. Three, the balance of the equities tip in their favor. And that four, an injunction is in the interest of the public interest. But here, that's on them. They bear the burden of showing each of those factors have been met. And he says, you have to show that you're going to succeed. And they have not even shown that we have jurisdiction over this. Standing is a preliminary threshold issue. They have not reached that yet. In order to have Article 3 standing, and how many 2020 cases did we cover here which were dismissed on standing or ripeness or latches or mootness or whatever basically standing jurisdictional issue that they could pull out of their booties. So here, enjoy it. You guys have not even shown that you are suffering an injury in fact that is particularized, actual, or imminent, and that they caused the injury and that we can do something about it. Giving us all the rules about what that means, and then does some analysis down here saying they want to stop this from going into effect. Because to do so, to compile a list, would be damaging to them. But the plaintiff organizations contend that they have standing because it's harm to their members and their voting rights. They say it's going to make it more difficult or even impossible. Like, what is the harm to them? For their members to vote. Why? Why would it be harder for them to vote? I don't understand. Because federal records will be used to create the lists that are virtually guaranteed to contain inaccuracies. So citizens who should have the right to vote will be caught up in a bad list and be dispossessed of their right to vote. that those inaccuracies will remain uncorrected, even though the order literally tells the states, provide modifications or amendments. Like, we're going to give you our list, then we're going to ask you to update the list, and then we'll have a nice unified list. So the order itself says, fix it. They're saying we can't. We're not going to be allowed to vote. Why? It says fix it. It's not just like a mandated list from the feds that will dispossess you. And that at least certain states will use lists to keep otherwise eligible voters from casting the ballots. And he says, come on. Judge Nichols writes, this, quote, highly attenuated chain of possibilities, but it could be this, and it could be that, and somebody could... It doesn't satisfy the requirement of an impending injury. The government hasn't even established infrastructure to compile these lists in the first place, nor has it determined how it will compile the lists or how it would be lawful. And so it remains completely speculative if and when they are compiled, if they will even contain inaccuracies. They're the federal government. They know everything. Even if they contain initial inaccuracies, the order requires the adoption of procedures that will allow people to go in, access it, and if necessary, update it. It thus remains speculative about whether that process will be ineffective. Can it resolve all or even most of the inaccuracies? Why should we invalidate everything because one guy might be labeled wrong and he can go fix it, but he may not have access to a computer and it might cause him irreparable and undue burdens in order to do that? So election integrity for all of us is invalid because one guy can't figure it out. Just like the one lady is capable of stopping the entire ballroom from being built because it hurts her view and she thinks it's going to be ugly. So, and whether the lists contain inaccuracies or not, nothing in the executive order even requires the states to use them, let alone to prevent otherwise qualified people from voting, because you, the DSCC, the NAACP, and the Latin American citizens can only speculate as to whether any voter would actually be disenfranchised. It's speculation. It is not certainly impending, which is what is required for an injunction. Now, even if they could show that it is likely that their members will be imminently excluded, they cannot demonstrate that that injury is traceable back to 2A. Again, nothing in 2A or any part of the order purports to require any state to do anything with the list, let alone remove certain people from their lists. Plaintiffs assume that certain states will rely on these lists, and the court recognizes that, yeah, some states will. The red states want the lists. But it remains highly speculative how they will adopt those lists and if they will do so in a manner that is consistent with federal law. So while it's not sufficiently predictable how this will happen downstream, it is not causation. You can't say that this law, this executive order, is ultimately leading to some disenfranchisement of some voter somewhere. Now, the plaintiff organizations also contend that it's a privacy right. They say their members will be harmed by having their transmission of their federal information transferred back to the states. But again, that injury is currently too speculative. After all, Homeland has not yet concluded that doing so is feasible and consistent with applicable law, including but not limited to the Privacy Act. They have not created the infrastructure for this, and they've neither compiled the list nor begun to transmit them. So how can you say it will be a violation when there's no explanation for the methodology about how they will gather the data or transmit the data? They say it would violate your privacy rights if they assemble a list, even if no information is ever transmitted. Okay, this is how freaked out they are. Okay, fine. You want the federal government to not give it to the state? Is that good enough for you? No, we don't even want you to assemble it. The feds can't even make their own list, period. Well, I thought the privacy violation is because somebody else would see it. No, it's also if you see it at the federal government level. That is, if a purely intra-federal government list is created, that's a violation of your privacy rights. But they fail to demonstrate that that action, that is the sharing of a name, age, residence between and among government agencies, if already known to the government, would cause harm that would be Article 3 standing. To determine whether that is a concrete injury, We have to ask if this is something that's commonly done. Here, they have not identified a historical or common law analog for an injury like this, which is the sharing of non-sensitive personal data, name, citizen, status, age, between different federal agencies. Happens all the time. And so now then they say, well, okay, if it's not a privacy right problem, and if it's not a voting rights problem, what else could it be? Oh, here is what it is. It interferes with their missions. These people are such, and forces them to divert resources to counteract its effects. So now they're going to have to spend money that they don't want to spend in order to talk about this and to combat this list making thing that's happening or the mail-in balloting that's happening. They say that because this law is coming into effect, they need to redesign their existing educational programs. They have to make more PowerPoint slides, and that's going to be very problematic for them. They have to retrain staff members. They have to distribute new informational materials. They have to monitor this to see if their members are on the list. And so that's going to cost us money. And so that's why we can sue to stop the federal government. It's like, how many times does the law change? Everybody has to deal with it. But when it comes to elections, if it makes you have to change things a little bit, can't change it. Period. That's their argument. The Supreme Court recently addressed this. They said the court explained an organization that has not suffered a concrete injury caused by an action cannot spend its way into simply gaining standing. Well, now we're being harmed because we're dumping out a bunch of money. The court accordingly held that the organizational plaintiff lacked standing, even though they had to go conduct their own studies on a drug. And that's not good enough. Same thing is happening here. They're saying that this is going to cause them efforts. They have to expend time and resources in order to educate their groups about how this works. They have to monitor the list and more. And that's not good enough here. Supreme Court has foreclosed a lot of this, but not all of it. But they have failed to meet the standard. It has to have directly affected and interfered with their core mission. Now, while it is unrebutted that those plaintiffs have expended and diverted resources, they're already preparing, name matching and are we on the list? Are you on the list? You're not on the list. Let's put you on the list. You're on the. I guess if somebody's on the list who shouldn't be on the list, they'll probably keep him there. But they say they cannot manufacture this. Right now, they have not established that we have jurisdiction over their claims. And finally, the Democrat plaintiffs say that political candidates, some of whom are plaintiffs here, have standing because it alters the rules of elections that they're actually competing in. He says, what are you talking about? This order does not purport to alter the rules of any state election at all. It doesn't order the states to do anything with the lists. It doesn't direct them to amend their procedures. Oh, and look who's suing here. Chuck U. Schumer and Hakeem Timu Obama Jeffries. Because the injury in fact analysis is the same, it doesn't impact them. They're running for state senate. They're running for House rep. And this doesn't change the election rules. All it's doing is creating a list. Now, alternatively, the plaintiffs say that the candidates have standing because it hurts their electoral prospects. They say Trump's order creates a serious risk to Democrat Party supporters, more so than Republican supporters, because they will be erroneously left off the lists. Why? Are they not citizens? Democrat Party supporters, if they're citizens, they'll be on the lists. What are they so mad about? Now, this claimed injury, again, it rests on a highly attenuated chain of possibilities. Democrat Party prospects, they say, would suffer. If that were to happen, something like this would need to happen. Judge gives us an example. Federal officials must determine that they can lawfully compile and transmit a list. Homeland must then compile and transmit the list with significant errors, even though the order expressly requires that not to happen. Those errors would need to remain uncorrected. State officials then must nevertheless decide to rely on those lists. So like all these things have to happen. And state election officials must then decide to use an erroneous list to remove eligible voters that would actually make it harder for their candidates to get elected. This speculation, based upon speculation, like inception of speculation, that's not Article 3 standing. And so since you don't have any standing, you're going to lose. Now, returning to Section B, which is about the Postal Service. First, the rule would require that all mail-in ballots be mailed in officially marked envelopes bearing unique barcodes to facilitate trafficking. So we know where it came from and where it's going. And we can track harvesting of the ballots and make sure we're not getting duplicate ballots, all with unique barcodes. Second, the rule would establish procedures for individuals to be enrolled in the list. And then the Postal Service would pick up the ballots, match a ballot with the list. We're not going to be taking mail-in ballots from people who are not on the list, like getting into a bar. You're not on the list, you're not getting in, because you're not a citizen. And this is a federal entity that's facilitating the transfer of these ballots. Now, plaintiffs say this interferes with our mission. It disenfranchises us. It harms our members, which is why they're so panicked about this. But the effects of this are even further removed from the lists. Unlike Section 2A, which does require the agencies to assess whether they compile this list, Section 3B directs only that the Postal Service initiate and then complete a rulemaking. Any injury, therefore, depends, again, on a series of contingencies. Whether the Postal Service issues a notice of rulemaking, what the rule says, what changes occur through notice and comment. You'll have your time to comment and object about it once we have a blanket rule that's fleshed out, and whether a final rule even issues. And then, once that rule issues, how it actually affects people. Now, they claim, therefore, and their claims, therefore, run directly into the bedrock. Ooh, and common sense. Yeah, they don't have much of that. Saying that even the issuance of a notice of proposed rulemaking. Okay, so we don't have a rule. We don't even have a proposed rule. Only thing we have is a notice that we're going to think about proposing a rule that will then go into effect. Can't even do that. No other preliminary proceedings have been undertaken, and so there's nothing to even sue about because several speculative contingencies must occur before there will be any concrete harm. You don't have any standing. Now, they argue they do, regardless of what any final rule might look like, that we're getting harmed now. Since they're thinking about proposing a rule that might go into effect, we have to divert resources. Like, look, we're suing. We have to retrain people. We have to reformulate a bunch of stuff. But again, that goes into the Supreme Court. Some hypothetical future harm. You can make a bunch of changes for whatever reason. Doesn't mean they're intelligent changes. You can start freaking out about whatever. But that doesn't mean it's going to happen. Now, plaintiff's challenge also suffers from a significant causation issue. Again, to establish standing, the injury must be traceable back to the action. Follow the bouncing ball. Trump did this thing, bounces here and harms you. You haven't done that. It's nothing more than conjecture at this time. They have failed to show that their challenge is likely ripe. And so ultimately, whether they want to frame this or whether we frame this as injury, causation, or ripeness, it requires more than the mere possibility of adverse regulation. And so that is, therefore, it is unsurprising that they lack standing. All that provision does is direct the Postal Service to indicate and initiate a rulemaking process. Now, they may eventually issue a final rule that does directly impact them and that they think is unlawful, but that is when they would have a personal stake that supports standing and come back and sue at that time. Right now, they're just thinking about it. And so, since they have no standing, they are unlikely to succeed on the merits. Ipso facto, bingo, bango, bongo, you're going to lose. In any event, the court will briefly address the facial standing here anyways. The facial challenge. They argue the president has no authority to issue the executive order. In this sense, they essentially eschew any challenge to future agency action and direct their challenge to the order itself. But the order is not self-executing. The president isn't doing this. He's not going over to the post office and making the changes. It does not itself regulate voter registration or how absentee ballots will be transmitted. All it's doing is directing officials to take certain actions that are literally within the law. That is a key distinction. While the president may not have the authority to change the design of the mail-in ballots or to remove individuals, he does have the authority to supervise and direct the actions of the agencies under his control. It's called the Constitution. Article 2, Section 1, Clause 1. The executive power shall be vested in a president of the United States. A president. That's the executive power, not a body, not a group of commissioners, a president. And that's exactly what is happening here. While the order does require the agencies to take certain actions, it also states in various places they have to follow the law. As a result, whether the government's actions under the order are lawful or unlawful will depend on how those agencies interpret the laws and how they enact these measures. But the fact that they might do something illegally isn't enough right now. Now, the court does recognize the agencies may implement the orders in ways that they say are unlawful. For example, the Postal Service may adopt a rule concerning absentee ballots that they may say exceeds your authority or is otherwise inconsistent with federal law. But it's not until those actions are taken that this will be ripe for judicial review. If that happens, then you can come back. But if you want an injunction, if you want to stop that now, you have to show irreparable harm. And you haven't done that here. They say their injuries are multiple ways. It's going to be an illegally structured electoral environment. It's going to harm their electoral prospects. It's pretty amazing that they admit that right here. You mean so just checking that the mail is valid is going to hurt your electoral chances? Why? Well, we know why. You're saying that having a list of citizens who participate in elections is going to damage your candidates? Why? Oh, they say it's disenfranchisement. The law provides for them to get reenfranchised. If they're accidentally disenfranchised, they get reenfranchised. Just go back on there, fill out the form, update the list. No one's saying to break the current laws. Now, it's also going to harm their voting rights. It's also going to stop them from advancing their missions of essentially registering anybody and everybody humanly possible to vote, regardless of status, residency, competency, and more, forcing them to revamp their education and turnout programs, which is, like we said, James O'Keefe and others, they've got people sitting on the corners registering crackheads. They go to homeless houses, homeless centers, register all the homeless people. All their ballots get poured in here. They can't validate whether they're voting or not. They're not coming back. Can I get my ballot to vote, please? We have a real serious take on Proposition 7. They're crackheads. That's the point. They're just getting warm bodies past the post. And in some cases, just mailing out duplicate, triplicate ballots. We've seen photos in many locations, and I've had this anecdotally happen, where I've gotten dead guys' votes and ballots sent back to my house. He's dead. I know he's dead. But a ballot's floating around. So if the feds know he's dead and say that guy shouldn't be getting a mail-in ballot, that is devastating to their turnout operation. The plaintiffs contend that the added difficulties, performance of their voter registration mission, James O'Keefe got that lady paying people to register and sign things, would cause imminent and irreparable harm. Now they have to change their scam, and it's going to cost them money to have to stop their turnout scam. But in any event, it doesn't command you to do anything. You're doing that on your own volition. Nobody's forcing you to have to go in and update your education materials and change your PowerPoint slides. No agency has acted yet. No one is causing you any harm at all, much less any certain great or imminent harm, period. And so for the foregoing reasons, your motion for a preliminary injunction is, where is it? Denied! Right there. The court will issue an order contemporaneously with this decision, signed by Carroll J. Nichols, and the Democrats are blown out. And they were very nervous about this one. So great decision, of course. Like I said, it's kind of a double-edged sword because that means we don't have a lot of new rules in effect. Once the rules go into effect, you better believe they're going to come back on this with aggression and say, oh, you can't make your own list. So it's a non-mandatory federal originated list, my privacy rights and more. So it's going to be a blood sport for the foreseeable future. Of course, we're going to keep our eye on that. Now, we spent a lot of time on this channel talking about the Louisiana versus Calais case, and that is now trickling back down to California. Jesus Osete, who is over at the Civil Rights Division, is now going after California's racist lists, following the same pattern and practice that we've seen in the other Calais matters, saying you guys drew a bunch of racist maps, you said, in a very stereotypical and discriminatory and bigoted racist fashion. All black people are like each other. And so we're going to give you a separate but equal congressional jurisdiction. And all Hispanics are like each other. And so we're going to bundle you guys up into your own district too. And you're going to be separate over here and separate, like you have your own drinking fountains or something. Which is very racist. I thought that we got rid of that a long time ago. But that's been their interpretation of the Voting Rights Act, Section 2, for a long time. And now the Supreme Court called that what it is, which is racist. Not allowed to do that. So stop drawing your maps in order to create a majority-minority district in the name of racial equity or equality when it isn't. Everybody gets the right to vote. Maps are drawn on a partisan basis. That's how it's always been. That's how it will always continue to be. California, of course, didn't want to do that. And so over the last however many years, they've been gerrymandering themselves into oblivion in order to draw these special racist districts. And so now the DOJ is coming out, and Ossetti just said that we submitted this one. And here is just the cover page of this, because we've seen many of these. It follows the same practice. But they say, bum, bada, bum, Louisiana versus Calais comes striking down in California. The Constitution almost never permits, never, a state to discriminate on the basis of race, which is what those maps do. California nevertheless discriminated on the basis of race when it drew new congressional districts using race as the predominant factor in order to enhance Hispanic voting power, treating all Hispanics the same. Like, well, we're just going to bundle you up and then you'll all vote blue because you guys can't think for yourselves. What kind of non-racist party is that? It's clearly racist. But specifically, they say that that is in violation of the Equal Protection Clause and Section 2 of the Voting Rights Act. Race was a predominant factor in drawing the boundaries in at least 16 congressional districts, all of which are Hispanic majority, because they're treating them as like separate but equal. Just put them all together. You guys are all the same. We're going to organize you by the color of your skin in America. Wild, but that's what they do. So the complaint alleges extensive and direct evidence of this racial discrimination. The map maker, called Paul Mitchell, made several, quote, public statements confirming that he intentionally and directly used race and Hispanic demographics as criteria in designing the map. Most notably, he publicly boasted that the number one thing that he first started thinking about when he was drawing these maps was drawing a replacement Latinx. It's not Latino, by the way, you bigots. It's Latinx. How dare you use gendered terms? Do you know how many trans Hispanics there are who don't appreciate that gendered language? It's a Latinx, majority minority district in the middle of LA. Their words. This is California. Several California legislators made similar public statements evincing their desire to empower Hispanic and Black voters by separating them out into their own little seats on a bus. So the complaint also describes circumstantial evidence of race discrimination as well. It details how California engaged in a deliberate practice of passing Hispanic majority census blocks from one adjacent district to another to preserve the number of Hispanic majority congressional districts, thereby achieving the racially motivated outcome of preserving 16 majority Hispanic citizen voting age population districts, but narrowing this majority to a tight range between 52 and 55%. Hispanic population in these districts. Now, that result was implausible without a deliberate, racially motivated draw using explicit racial means. And so we're now suing. Supreme Court just came down, said you can't do that anymore. We're not doing this racist map crap anymore. The maps can be drawn partisanly. That's fine. So you can say, you can redraw those and you can say, well, we're going to do this because the Democrats will win this. Great. Might be the exact same map, but you can't make it explicitly about race because that is racist. And I can't believe this Paul Mitchell guy is not honoring Latinx. He's from California. It's very offensive for the Latinxos. So that is what we saw there. Now, elsewhere, the House Administrative Committee in the GOP is saying that they're also demanding answers over the state's massive mail-in ballot issue. They reissued 500,000 mail-in ballots. They sent 500,000 out. Those were problematic. Then they resent another 500,000. And juxtapose that with their argument that we can't have any lists. Nobody can make federal lists because those will be problematic. It might disenfranchise some voters. How about sending out 500,000 incorrect ballots? Do you think that that might disenfranchise some voters? People will guarantee it. It's the law of big numbers. A certain percentage of those people will use the bad ballot, vote on it, send it back. When they get the new ballot, because they're honest, they won't vote on the correct ballot. And so their vote, presumably, since they have to throw out the bad ballots, will not count. Or it will count on a bad ballot because they don't want to disenfranchise the voters. The whole election is totally botched. And that is because they're incompetent. That's in Maryland with Wes Moore. So now the House Admin Committee is now saying, all right, we got to investigate this. Completely ridiculous. So they sent a letter to the State Board of Elections in Maryland. They said, all right, you know, our Congressional Committee has broad oversight over federal elections, and elections are critical to the integrity of America. Now, your office, the State Board of Elections, that I'm sure would be objecting to the feds helping them with the list, recently reported a vendor error. It's always an error, too, that resulted in many voters getting the wrong party ballot. This issue merits careful attention, and so now we want some information. On May 5th, your office announced that 565,639 voters requested mail-in ballots for the primaries. Following the first phase of mailing these ballots, a grave error was discovered. A printing and mailing vendor distributed incorrect party ballots to an unknown number of voters because the number of incorrect ballots could not be determined, which is crazy. The SBOE announced it would preemptively send replacement ballots to every voter who requested a mail-in ballot. Everyone gets a new ballot. And that's wild to me that they can't even, you don't even have a list of people to whom you sent a ballot? Not even tracking that? That cost a bunch of money. How much money is that? So they have no idea. So oversight continues to say, while the SBOE is taking precautions to void the initial batch of ballots, distributing over 500,000 additional ballots creates a risk of immense logistical strain and potentially undermines public confidence in our elections. These systemic errors raise concerns over pre-distribution auditing and state oversight of critical contractors who apparently are blowing through hundreds of thousands of dollars, mailing out hundreds of thousands of ballots. Based on this information, the committee is concerned about the administration, the tracking, the security of your process for mail-in ballots, and whether adequate safeguards are even in place to track this. So to assist us in our oversight, we want to know the following information from you. 1, what specific mechanical, digital, or procedural error within the third-party vendor system caused this error? What protocols does the State Board of Elections have in place to audit and verify the accuracy of these ballots prior to distributing them? Did somebody even check? Does the election board plan to alter these protocols since you guys botched this? How many of the approximately 565,000 original ballots are estimated to be incorrect? If a voter returns only the original, incorrect mail-in ballot? Is the entire ballot discarded such that none of the voters' selections are even counted? What corrective actions or contractual changes is the Board of Elections implementing to prevent similar vendor errors in the future? Has the board launched a formal internal investigation to figure out what the hell happened here? If yes, what are the preliminary findings? And how will the board ensure a similar incident does not occur prior to the November election? Sincerely, your friend, Brian Steele, Chairman, Committee on House Administration. And those are my questions too. What if they vote twice on the ballots? Incorrect one comes in. How can you verify unequivocally that the bad ballots are being booted and the good ballot is being accepted? Or do you count two votes? Or if they only vote on the first one, even if it's the wrong party, and they don't vote on the second one because they go, oh, it's a duplicate, I'm obviously not going to vote twice, and they don't know about this. Many people are not as plugged in as we are. Do they disenfranchise that voter? Does that entire bad ballot just get completely shredded? So now they can't participate? Yeah, very interesting here. And these are the same people who are going to sue and whine and moan about any election integrity reforms, any checks and balances, any oversight at all. It's a privacy violation. It's harming our mission, like the NAACP said. And it is damaging their potential electoral prospects for their political party. So that also happened. And then another big one from Osetti, they're also submitting their brief in the Supreme Court of the United States. Tons of action today. He said, the National Voter Registration Act does not prohibit states from removing non-citizens from their voter rolls. We're going to SCOTUS. Today, Civil Rights and the Office of the Solicitor General asked SCOTUS to grant cert and resolve this once and for all. And here's what they submitted into the Supreme Court on this case. Versus RNC suing Mi Familia Vota. Warren Peterson from Arizona versus Mi Familia Vota. Can't even speak English in your companies. Arizona versus Promise America. Brief for the United States. We'll hit the highlights of this one because we're going to have a lot more on this in SCOTUS land coming up very soon. But they say, you know, following the 2020 election, which was rigged, Arizona, shout out, joined a number of states in amending its laws to better counteract voter fraud. Among other things, Arizona implemented a program to remove non-citizens, and it imposed a requirement that individuals must provide certain proof of citizenship in order to register to vote on a state registration form. This case is principally about whether those common sense election integrity measures are preempted by the NVRA. So does federal law prevent a local state from cleaning up their lists? Now, as this court preliminary recognized when it stayed two lower court orders enjoining these measures ahead of 2024, including this case, these policies are not preempted. The NVRA does not prevent them from cleaning the list up. Okay, Chris Mays, Arizona's AG, and Adrian Fontes, who threatened people with felonies in Arizona for daring to comply with federal subpoenas. They do not want to fix the lists, and they just search and scour around federal law, and they say, oh, we can't. Oh, no, the NVRA says we're not allowed to do that. DOJ is saying, yes, you can, you jerks. In fact, you have to, because it is illegal to have non-citizens on there voting. He explains. Now, as to the voter roll question, the NVRA's restriction on removing individuals from the list does not apply to non-citizens. They were never eligible in the first place. The Ninth Circuit and their contrary decision is badly mistaken. It deepens a circuit split and risks significant harm. Indeed, on the reasoning of the decision below, a state could never remove any non-citizen under their interpretation. That cannot be correct. That cries out for reversal. And so, Supreme Court, we need your help. Now, as to the registration form question, While the current federal reform requires only that applicants attest to their citizenship, the NVRA, the federal law, grants states the flexibility to require their own forms that applicants supply proof of citizenship with. In fact, this court cited a prior proof of citizenship requirement in Arizona, and the Ninth Circuit's contrary decision cannot be reconciled with other provisions of the law, the Supreme Court case from 2013 called Intertribal Council of Arizona. So the RNC is suing on this too. They present both sides of these questions, and the petition offers an opportunity, Supreme Court, for you. Solve these important election issues right now. And while the courts below held that Arizona's proof of citizenship requirement was unlawful under a federal consent decree, so again, what happens is Biden's people probably, and I don't know the exact specifics of this consent decree, but they come in and they enter into settlement agreements essentially. And they say, okay, Arizona law says this, your law says this, so we're not going to check citizenship. And that holding is more a feature than a bug because it too is worthy of review, saying you should also analyze this little settlement agreement. Okay, the best example that we've covered here was when the blue states were being sued by blue Democrat, nonprofits and NGOs, and then blue judges would enter in a settlement agreement that they came to. Mark Elias Group would sue Jocelyn Benson in Michigan. They would settle it, and they would change all the rules and say, well, it's a good point. We don't want to be sued. We might be in violation of the law. So let's just take a plea agreement kind of a thing, enter into a settlement agreement. Blue judge would stamp on it. All of the election rules would be changed because of COVID or whatever extenuating circumstances exist. And that would bypass the state legislature, which controls the elections. New rules would go out. Election gets rigged. Same thing in Arizona. Now, even though the consent decree was not based on any adjudicated violation of federal law and was expressly premised on consistency with then existing state law, the courts below extended the decree to bar enforcement of a subsequently enacted state law. And whether a federal consent decree must yield to a state law given such significantly changed circumstances is definitely worth it for you to hear. And so Supreme Court, grant this. And lots more on this one. And so this will be working its way up to the Supreme Court. So the court should grant the RNC's petition. This is the DOJ now weighing in. They're not a party to the lawsuit specifically, I believe. They are an official party. And we're kind of named in this whole series of litigation. But they say, you should grant this, deny the petitions of the legislators and the state, and allow this case to go forward so that we can actually validate whether states can remove non-citizens from the list and whether proof of citizenship should be required in order to conduct your elections, as Arizonans want. So, lots of activity. Hopefully the Supreme Court grants that one. Here's more from Harmeet Dillon. She was on with Michael Malice over on his show, You're Welcome, saying, at the DOJ, the civil rights voting section protects our nation's values by cleaning up these voter rolls and safeguarding elections. I see America as truly exceptional for the freedoms and liberties we are granted. Me too, Harmeet. Here's what she had to say.
I hope in the future someone watches this and understands that you can come to DC and make some sacrifices and have an impact. And it's actually feels really good to be able to do that, because I love this country, and I think I'm an immigrant. Not enough Americans have traveled or come from another country and know what it's like in the rest of the world. People have no idea how great we have it in America and how close we are to losing it with every single election.
Yeah, to the communists that are out there that want the foreigners to actually govern America and turn America into their foreign lands so that they can have perpetual, never-ending power. So Harmeet's on it. The DOJ's got multiple briefs. We're going to California. We're going to the Supreme Court. Big victory out of D.C. on the Trump executive order. Lots more to come. We're going to keep our eye on all this election litigation and more. Thank you for joining and subscribing as we keep our eye right here on this. Now, we've got some other fraudsters to talk about, and this one's a good one that we're looking forward to seeing develop because we covered this case extensively, and hopefully justice is coming soon. E. Jean Carroll, the Trump accuser who said that she got Bergdorfed in a dressing room at Bergdorf's, who really couldn't remember anything about the date, time, location, year, month, time, anything about it at all, now might have committed perjury. And CNN had the exclusive on this. No official acknowledgement from the DOJ. But we remember the situation with this woman, and it was a civil lawsuit that was ultimately filed against the president. She made a couple of claims in there saying that, one, he R'd her in the dressing rooms. You know what that means. That means the P and the V. And the jury found by a preponderance of the evidence, okay, like the lowest standard that we have in civil or criminal law, which is more likely than not. 51%, preponderance of the evidence kind of adds up, kind of tips over this way. Not beyond a reasonable doubt, not clear and convincing evidence, preponderance of the evidence. Did Trump R Miss Carroll? Answer, no. Now, on to the second question, was there a little, handsy business going on down there? They found yes, and part of the evidence on that was Trump's grab him by the purse tape that made its rounds all throughout the election. So every time you hear somebody say Trump R'd a woman, from my opinion, that's a lie. Now, the judge came back and wrote a follow-up decision, and he said, well, digital penetration is also an R, because he was so dead set on making sure that that R claim could continue forward. But as we saw, George Slopadopoulos got sued. I think ABC settled that one for $15 million. And we have questions about how this whole case originated. Remember, the statute of limitations for a civil lawsuit like this had already expired, was not a criminal case. So in New York, where this all originated, Southern District of New York, they extended the statute of limitations and allowed her, E. Jean Carroll, who, according to many reports, got the idea for the lawsuit at a party with Molly Jong-Fest, a liberal lunatic, who also had George Conway there. She was there. They started putting together a team. They got the whole lawsuit funded over multiple years. They changed New York law in order to allow her to file a civil suit. Whole thing funded by Reid Hoffman. And we know who that guy is because of Epstein's Island. And he's the LinkedIn co-founder and a Democrat super billionaire who had too many ties to Epstein and then started to fund the victims' cause as well and funnels money into Democrat causes, including like E. Jean Carroll's lawsuit. And our friend Maze Moore over on X, you know who he is, we comment on him a lot, said E. Jean Carroll said during her 2022 deposition that no one besides her was paying her legal fees, which she did. And here's Reid Hoffman saying, actually, he did fund the case. This is why she is now under investigation for perjury. And we'll see what the courts had to say about that as well. But here is Reid Hoffman.
My team looked at it and thought that it was that her voice should be heard, that because she was challenging someone who's so much more wealthy and powerful, it shouldn't be squashed. And that, providing that voice for, people who are otherwise would be ground down by the system or the powerful is, I think, a good thing. Obviously, especially in the case of women, and obviously, especially in the case of sexual and other, torture and attack so providing that support was something that I felt very happy to do.
Yep, paid for it.
Speaking truth to power and having a woman have her voice, having a chance to be heard and not squashed through the legal courts because she didn't have the money to fully pursue it, I thought was a good thing for society, not just for her. And obviously, the point is that courts should go through their process, and the fact that the court found President Trump guilty doesn't surprise me. And I think that one of the things we stand for as Americans, a rule of law and a good judiciary process. And I think,
yeah, not for the R, by the way. and it is liable. Okay, it's not a criminal case, so he was found liable for the handsy in a dressing room at Bergdorf's, where there's no other witnesses to the event, did not report it to the police, no forensic evidence at all, called some friends who hate Trump, who then said, yeah, I kind of talked to her and she kind of mentioned something. And ultimately, no security camera footage. She couldn't even remember the date or the year at first until she pinned it down, I think, in the second trial. And you could just say it's this year. Like, sure. No evidence at all to disprove anything that she's saying. They presented a photo of the president that was in a photo line with her and didn't even recognize her. It's like, who the hell is this lady? He takes pictures with people all over the country. She also, of course, is the same woman who had the entire story, in my opinion, lifted off of a Law & Order SVU story, where one of the victims got Bergdorfed in a dressing room at Bergdorf's. She's essentially crazy. She also has painted her trees blue. She's like an author. She named her cat Vagina. She explained that she was a major fan of The Apprentice, so she was watching her rapist, apparently, on TV years after it happened. I love the guy. All right. So anyways, there was a question about who was ultimately paying for all of this. She said no one was helping her pay. Now, Reid Hoffman is a visceral, salivating anti-Trumper who funds tons of nonprofits and C3s and all sorts of things that wage war on behalf of the Democratic Party. And when it came up, she said, yes, I'm paying for it. My lawyers are funding this. It's all self-funded. Then it went up on appeal. And what's so interesting about this, Roger Parloff, who is no fan of Trump, he says, and clip this for us, but he said, second, this came from the Court of Appeals. They said that the fact that she did not mention that Reid Hoffman was actually funding the lawsuit was just a lapse in memory. It's not an intentional lie. It's not perjury, because she forgot. And of course, pretty amazing that she forgot something just 2 years old, like who is paying for her lawsuit, but her memory is so crisp that she can give you the details about what happened in a dressing room 30 years ago. Second Circuit said this. The district court did not abuse its discretion in precluding cross-examination on this point. Should we have been able to go in and hammer E. Jean on this? You know, this whole lawsuit is being funded by a leftist lunatic called Reid Hoffman. And Democrats, George Conway, Molly Jong-Fest, all frothing anti-Trumpers. So she's basically a pawn on this. Maybe you don't even blame her because she's out of her mind. But you're being funded. Okay, the whole lawsuit is emanating out of a taint, out of Reid Hoffman's taint. And so should we have been allowed to ask her about that? Judge, during the trial, said no. Like many other areas of inquiry that should have been appropriate, judge said no. The district court found that the prior statement on the litigation funding was not sufficiently probative of her credibility. So you're being funded by Democrats in order to take the president out, and that is not indicative of whether she's telling the truth or not. Now, the Court of Appeals said, that's fine. Yeah, the judge down below did the right thing by not allowing this testimony to come out. Court of Appeals says, Ms. Carroll plausibly represented that she had forgotten about the limited outside funding counsel that was obtained in September 2020 when this question was first posed to her in 2022. And the additional discovery did not indicate that she was lying. Rather, it showed that Ms. Carroll simply was not involved in the matter of who was or was not funding her litigation costs. Ms. Carroll testified that after her counsel informed her in late September 2020 that they had received some outside funding, she did not speak with her lawyer again about this topic until the spring of 23 and did not even know the funders' political position or why they were partially funding her lawsuit. Therefore, by the time of her deposition in October, Ms. Carroll had not spoken with her counsel about that, and she forgot. Okay, so she just didn't really look into it, didn't really care. It doesn't impact the taint of the lawsuit. The fact that it's being funded by Democrat operatives who are literally campaigning against Trump every single day. Not relevant, not probative. She didn't know. She didn't have a need to know. The fact that she didn't ask about it, also not relevant at all, and has no impact on the ultimate litigation that was pending at the time. So Court of Appeals also says the same thing, saying it was outside about the matter of outside funding for over 2 years. It was not an abuse of the lower court's discretion to conclude that the available litigation funding evidence would have little probative value compared to its potential for unfair prejudice. And boy, it would have been prejudicial. Not really. It's New York. They wouldn't have cared, I think, anyways. Maybe. I mean, they split it. They didn't believe her on the R claim. The main claim, like this doesn't get enough attention. Her main claim was that she got R'd. Trump R'd her in a dressing room. The jury said, no, he didn't, you crazy person. He didn't. We don't think you're credible. They gave her the gimme because they probably hate Trump, and they're grabbed by the purse tape and all that. No other evidence other than that, which is propensity evidence, which is not even the real quote. He was saying they let you do it when you're famous, which I've heard they do, but I don't know. But that's, of course, not even relevant to this case. So talk about fairness and unfairness and probative and prejudicial and all the things. So judge did not let that in. And now they're saying she lied about that. She knew where the funding was coming from, and this is why she's under DOJ investigation. So the DOJ now, according to CNN, has launched a criminal investigation into E. Jean Carroll, according to multiple sources familiar with the matter. It's focused on whether she committed perjury in testimony tied to her 2 civil lawsuits, one where she alleged that she was, now they changed it, right, from R to abused, because the jury said he didn't R you, in a department store, Bergdorf's, in a dressing room, getting Bergdorfed in Bergdorf's. Now, a second one defaming her when he repeatedly denied the assault. Again, in 2019, he denied it happened. The president has presidential immunity in the 3 buckets. This whole thing should be going bye-bye. But he was defending his honor as the president. Okay, I would argue that's part of your duty. You're the leader of the country. Somebody comes out and accuses you of R-ing a woman in the dressing room. You either admit it if it's true, or you have to deny that to protect your integrity as the commander-in-chief, as the leader of the country. If you just let those statements stay, then you are in a way acknowledging them, or not acknowledging them kind of makes by implication that they might be true. So Trump came out and denied it. They said that was defamation. So the theory hinges on a 2022 deposition statement by Carroll, now 82. She said in a depo she received no outside funding for her lawsuit. She definitely did. It was revealed that billionaire Reid Hoffman, that tub of goo we just heard, had paid some legal fees and expenses. Now, Carroll's team declined to comment for this story. Attempts to reach Reid and his taint were unsuccessful. The probe is the latest move in... CNN is such a joke. Target his long-standing personal foes. It's not really that. She's a liar, in my opinion, and now she should be held accountable for a fraudulent conspiratorial lawsuit. Todd Blanche is now launching this. CNN is filled with hacks. Who's this shameful person who wrote this? Oh, 3 dorks had to write it. Three ladies. Hannah Rabinowitz, Paula Reed, and Kara. Great job, ladies. So they write this together. Every other paragraph is about retribution. Senior leaders at the DOJ referred the investigation to federal prosecutors in Chicago, according to 2 sources familiar with the matter. While Carroll's depo took place in New York, one of the individuals who helped cover some of the legal fees, Hoffman, has a nonprofit based in Chicago. Hoffman's support of the case caught Trump's attorneys off guard when it came to light on the eve of the trial. In a 2022 videotaped depo, Carroll told then attorney Alina Abba, no one was paying the legal fees, but 2 weeks before the trial, Carroll's lawyers informed the judge and Trump's lawyers they got funding from Reid Hoffman. Carroll's lawyers said she never met him, never had conversations with him, and her lawyers knew about this. They knew that she lied in the 2022 depo. They waited until the eve of trial knowing the judge was going to give them a beneficial ruling. Abba said in court that Carroll's lawyers conspired to conceal the truth for 6 months, and they did. The judge permitted Trump's lawyers to question Carroll in the depot. That has not been made public. When the trial began 2 weeks later, Judge Lewis Kaplan, no relation to E. Jean's lawyer, Roberta Kaplan, said he saw no issue with her credibility. Oh, so what? Who's paying for it? I know, Reed. And blocked the lawyers from asking about the funding at all. Now, Carroll, of course, is still involved in a battle. Trump is now taking this case to the Supreme Court. I think he's got immunity. I think he's going to win at least the defamation case. The Supreme Court has deferred its decision on whether to take this up 12 times. Every time we check the docket, they postpone it, postpone it, postpone it. The most recent deferral was made this week. Now, in a different case, the president unsuccessfully asked for the Justice Department to join a case as a defendant so that he could argue he is immune from liability. An appeals court said that argument was raised too late in the legal process. Yeah, so sorry, it's a little too late. So she may be in big trouble. And now we're looking forward to maybe some perjury charges coming soon. So that's Reid Hoffman. Now, some other anti-Trump fraud attackers come from New York. You know who they are. Alvin Bragg, the guy who led the case against Trump for those 34 bookkeeping felonies that were not really felonies. They had to find another law in order to kind of shoehorn them into a subsection to make them felonies because the statute of limitations had expired on that one too. And so it's so wild to hear these CNN people like this, Hannah, Paula, and Kara, all crying about weaponization or retribution or political foes or whatever, when we literally watch them fund lawsuits from billionaires that were paid for by this guy, extend statute of limitations in New York, and then reconfigure the entire law, have acting judge Juan the Con Mercan and others preside over the cases to try to take Trump out. Well, now the judiciary GOP is going after Alvin and Letish. And they said this one, Manhattan DA Alvin Bragg bent the law in his politically motivated prosecution of President Trump. But when it comes to criminal aliens, he refuses to enforce the law that's on the books, saying New York City would be safer if Bragg did his job. He's not going to do that. So they sent over a letter about these criminal illegal aliens, and here's what it said. They said, hey, Alvy, we're now conducting oversight of jurisdictions that endanger American communities by refusing to cooperate with feds about the enforcement of our laws. We now want information about your sanctuary policies, saying during your tenure, the Manhattan DA's office has routinely undermined the rule of law for years. Your office is openly given preferential treatment to aliens solely based on their immigration status, which of course we know they get. Illegal aliens get due process premium plus ultra version. If they're in America, you just get basic. Sucks compared to what they get. It's weird too, because we pay a lot more than them, but still we get basic, Can I have that feature? No. Can I? No, you can't have that. Peasant, citizen, go to jail. In your first days in office, you announced special procedures for cases involving dangerous foreign nationals. You specified that your office would, quote, seek dispositions that avoid immigration consequences for all misdemeanors and all felonies for which non-carceral outcomes are the presumptive outcome. Okay, so if an illegal alien comes and commits a felony, the prosecutors will try to configure a plea or an outcome that means you don't go to jail, because if you go to jail, ICE may come get you. And we don't want immigration consequences because criminal charges have collateral immigration consequences. Have to report that stuff if you're applying for permanent residency or citizenship. So in practice, these policies ensure that criminal aliens can literally commit crimes and remain in the U.S. and not face deportation. Now, if you're a citizen and you commit a felony, some white guy somewhere, totally different set of rules apply to you on their face in New York. That's why you have to get the hell out of there. Which is probably what they want, by the way. They want just a filter to get rid of the non-favored population. Like, that's why these rules exist, I think. To push the non-favored population out, to give special privileges for the favored population, to change the demographics of the entire city. You go to jail because you're a citizen who's a different ethnicity, but you go free because you're a foreign invader and we like your skin color. So you have also advocated for laws that not only prevent immigration enforcement, but also imperil law enforcement, the community and aliens. And so to protect these communities from dangerous nationals, ICE arrests these people in courthouses. It's safer than breaking into homes or getting arrest warrants and going into homes. The arrests are also safer for the community because they ensure aliens are not free to reoffend. And even Biden-Harris people confirmed that arresting criminal aliens inside a courthouse is safer for law enforcement and for everybody. But nonetheless, you have endorsed prohibitions on arresting aliens at courthouses. You falsely claim that the policy is detrimental to law enforcement and to public safety. The effects of your office pro-criminal alien policies have been devastating. In one case from earlier this year, listen to this. You offered a sweetheart plea deal to a 31-year-old transgender woman, I think that's probably debatable, from Colombia. Okay, it's their quotes, so it's definitely a dude. 31-year-old transgender woman from Colombia, even though the illegal alien sexually assaulted a 14-year-old boy in a New York bodega in 2025. Plea deal. As a result, the illegal alien who the Biden-Harris administration released into the U.S. in 2023 will serve less than 1 year in jail for sexually assaulting a 14-year-old boy in New York. Some Colombian tranny comes in here and then starts wild. So under your office's pro-crime, pro-illegal immigration policies, illegal alien criminals are allowed to freely operate, terrorize local communities, and reoffend without consequence. Like other sanctuary jurisdictions, we have examined the shielding of these aliens undermines public safety. And so accordingly, we got some questions for you. We want to know about all documents and communications about how you're processing these people. All documents referring to your policies related to the prosecution of non-citizens and how you interface with ICE. All documents about how you come up with initial charges and what the ultimate dispositions are. Active and closed cases that have led to an alien to replead or authorize them to replead. Active or closed cases in which an alien defendant had a conviction that was reduced. Any cases where you recommended a pardon. We want all documents about ICE, all training materials, anything related to how these non-citizens post bond, how you interface with the New York Police Department, DOC, and other things. We'd like answers to these questions no later than June 10th. Thank you for your cooperation and your prompt attention to this matter. Sincerely, Jim Jordan, Chairman on Judiciary, and Tom McClintock, Chairman, Subcommittee on Immigration and Enforcement. And it's like, this is what they want. The policies, the point of the policies are what they do, right? The point of the system is what it does. They might say it's another thing, but it's what it does. It's releasing transgender pedophiles back into the society after 1 year in jail in a bodega. Sick, sick situation. But that's Alvin Bragg. They'd rather spend their entire prosecutorial budget going after President Trump and going after, I guess, citizens who are not illegals. So it's a pretty disgusting dumpster over there. But Scott Bessent was out today, was asked questions about this new commission and fund, and said, you know, Trump and many others endured were victims because they were harassed by a weaponized government for years. And here's what Scott had to say about this all today.
President Trump is a great American who has endured more than 10 years of nonstop harassment and weaponization from the federal and state government actors. A bad actor at the IRS leaked more than 400,000 tax returns, including the Trump family, all the employees, and that's how we got here now. No American should be targeted for political reasons, and every citizen deserves fair treatment and full protection of the law. The Department of Justice represented Treasury and the IRS in this matter, and I'm going to have to refer any questions to Acting Attorney General Todd Blanche. So, President Trump.
That's right. They weaponized the government. They had due process premium for certain people and due process minimum, basic due process. You're a J6er. It's like, I guess we'll read you your right. Go to jail in solitary confinement and enjoy the bed bugs. But fortunately, what we see is now Trump is back in power. Everything that they threw at him and at the other side of their political aisle failed, and now they're going to have to suffer the consequences for their crimes. E. Jean Carroll under investigation, Alvin, Bragg, and Letitia James also under scrutiny from Congress. We're going to keep our eye on this one. Thank you for subscribing and joining as we do. We got one more update, my friends, and we're going back to Minnesota, where we've got these two ladies now been arrested. A massive Somali fraudster bust now underway. These two criminally charged for allegedly stealing $21.1 million in a Medicaid fraud scheme, all happening out of Minnesota. We've got the charging documents queued up in the press release from Homeland saying one person's name is called Shamso Ahmed Hassan, and the other one is called Hanan Mursal Yusuf, submitted false and fraudulent claims to Medicaid for 4 years, May 2020 to December 2024, and they started Smart Therapy Center, LLC, and Star Autism Center, LLC. Once again, stealing money from actually autistic kids who could use some help, but it goes to the Somali community, who I don't officially think is autistic, but might have some close parallels. Now, here's what Homeland said. They have now been arrested, $21 million, ripped off from the American taxpayer. Homeland Security in St. Paul reported the arrest of these two. Charges: conspiracy to commit healthcare fraud, 8 counts of healthcare fraud, 2 counts of money laundering. More photos here. The owner of Smart Therapy LLC, Smart Autism, she enrolled as a provider of services. The funds went flowing out. I wonder if they'll get 6 months in jail or if they'll get 41 years like Amy Bach. Now, though both companies, they carried out a scheme to defraud $21 million over more than 4 years. And the Assistant Secretary, Lauren, said, these Minnesota residents have been accused of stealing more than $21 million. You know how much money that is? They now face charges. Their scheme started during the COVID, lasted for 4 years. ICE continues to zero in on the rampant fraud. Under Mullen, we were going to end the defrauding of the American people. And now they've been charged. Here's the case emanating out of the District of Minnesota. And it originally came back in an indictment back on May 20th. A lot of this now coming to light after the press release. They just had their arraignment, it looks like, this week. And the reading of the indictment was waived. A not guilty plea has been entered by both of them. And let's take a look at the charging document. So via indictment against these two, Shamso and Hanan, with a bunch of different charges under 18 U.S. Code and 21 and 28, saying here's what's going on. Now, we know what Medicaid is, so we can fast forward through some of this. It's a long-term program that's supposed to be for needy Americans. And Medicaid and others, we refer to them under certain titles. We've covered a lot of fraud cases. We get all of this. Now, autism, is a neurological and development disorder. And there's therapy for it. And there's programs that are federally funded in Minnesota. We pay taxes. It goes into the coffer. Then they send it back out to the Minnesotans. Bunch of treatment gets delivered. Level 1, level 2 providers all provide treatments. They go through Medicaid. They get reimbursed. They're supposed to keep records. They're supposed to follow the law. retain claims for 5 years, have good billing procedures. They have to bill for stuff they actually did. And they can only bill after the services have been provided. You have to disclose identities. You have to be an owner. Now, here's what they did in violation of all of that. Defendant Shamzo was a resident of the state of Minnesota and an owner of Smart Therapy, LLC, and Star Autism. So on February 7, 2023, Shamzo enrolled as a level 2 provider of autism services. Now, the other person, Yusuf, was a resident of Minnesota as well and an employee. And Yusuf was the lead biller for Smart Therapy. She would submit the claims over to Medicaid. In 2020, Hanan Yusuf enrolled also as a provider, and same thing, a level 1 provider, and they billed at the Medicaid rates. Other co-conspirators involved, co-conspirator 1, another resident and another owner who probably is like, man, I hope I don't get charged. Co-conspirator 2, another resident and a beneficial owner of Star Autism. Individual 1 was a husband and another owner. So he's like, so long, honey. Have a nice trip back home. On or about November 21, 2019, co-conspirator 1 formed Smart Therapy and enrolled Smart Therapy into the programs. Then on December 10th, co-conspirator 1 submitted a disclosure of ownership. He's 100% owner. Then Shamzo comes in. She now splits it. She becomes 50% owner. And individual 1 comes in, 25% owner. Executing an operating agreement explaining who owns what shares. And they were all involved in this. And Shamzo and Yusuf got a bunch of money, significant profit distributions. And Yusuf also got a bunch of money. She had no ownership interest, but I'm sure she was doing the billing. And so they were giving her kickbacks and paying her to basically commit the fraud. So here's how it went down now. On August 24th, they formed this Star Autism entity. And again, this is the same thing for Star Autism. They created operating agreements and more. Then what we've got are the charges. Here is the conspiracy. Now, it was the purpose of the conspiracy to unlawfully enrich themselves. They submitted fraudulent claims on behalf of both of these entities. They submitted fraudulent certifications and enrollment forms. They paid illegal kickbacks and bribes to parents in exchange for enrollment of their kids in their companies. Your kid has autism. No, he doesn't. He's fine. What are you talking about? He's doing it. I think he's got autism. Let me pay you a couple, grand to come and do that. They concealed the submission and made false and fraudulent representations. And here's how they did it. All right. So they knowingly and willfully submitted claims. They provided services that were medically unnecessary. They were rendered to recipients who appeared to be diagnosed with autism, regardless of the medical necessity. You have autism. You have autism. No, I don't. Yes, you do. Okay. In some instances, providers did work for Smart Therapy. They continued to submit claims for kids who didn't need them. The centers enrolled these individuals with Homeland. They billed for services, and they did it all without the individual's knowledge. Sick, man, to steal from kids. And they would ask for reimbursement. They knowingly and willfully submitted significantly inflated claims for reimbursement and caregiver training. The training was rarely, if ever, provided. Between April 23 and October 24, Smart Therapy submitted claims for reimbursement to Homeland for DHS, which is in Minnesota, Department of Health Services, for over 3,000 hours of training. For a single Medicaid recipient's family, never provided. The recipient's family never received any training from Smart Therapy at all. 3,000 hours. Now, they also submitted illegal forms, false and fraudulent forms to conceal and disguise their role. And they paid illegal kickbacks of approximately $300 to $1,500 per month per child in exchange for the enrollment of those kids. And all those people should be charged. If you're a parent who is exploiting your child to make $1,500 a month in the furtherance of Medicaid fraud, you're a co-conspirator. They should all be charged. And they can take, lenient plea deals or be deported. Oh, it's gross. we're supposed to live in an honorable society where you didn't just run into the nearest government location and just start ripping off your fellow countrymen. How could you possibly think that getting $1,500 a month, like they're paying you for giving them your kid's name and your kid never goes there, and you just get $1,500 a month? They would disguise the kickbacks by writing checks payable to family members and employees and directing them to cash the checks and give the cash to parents monthly. And by referring to the illegal kickback scheme, they used a code word called computer. And these are fraudsters, okay? These parents with these kids who are being exploited are exploiting their kids, and they're fraudsters. So this fraud is over, but they're going to continue to act fraudulently until they are punished for that. Shamso had access to bank accounts, and so it sounds like they would write checks to their other friends. Like, so Shamso would write checks to their family members, then the family members would cash the checks, and the family members would then pay the parents. All one big grift. Shamso had also access to bank accounts held in the name of Smart Therapy and wrote multiple high-dollar checks to herself and her co-conspirators. In numerous instances, Shamso also received checks from the company. She had no legitimate basis for receiving that money at all. Then they would submit false claims for things that were not actually eligible and procured illegal kickbacks in an amount of $46 million. And Smart Therapy and Star Autism were ultimately reimbursed approximately $21 million. So they billed $46 million and they got 21. Do you know how much money that is? Like, if you have a small business, if you've ever run or owned or worked in a small business, do you know how much money that is? It's insane. From in or around April 2023, Smart Therapy submitted $346,000 in claims for reimbursement and got $141,000 back. May 22nd, May 22 to 24, another $676,000 in claims, got reimbursed $300,000 for that. The others then diverted hundreds of thousands of dollars of the fraud proceeds that came from Minnesota Medicaid for their families and their personal use and benefit. And they sent money back over to Kenya. Okay, get it out of the country, man. So you can't go claw it back. It's in Kenya. They also committed healthcare fraud across multiple dates. Here's how they did it. They aided and abetted each other, knowingly and willfully executing a bunch of things, and submitted fraudulent claims and got delivery and payment of the following. Claim number, individual intervention, adaptive behavior treatment, 7 hours, didn't happen, $3,000. 4 hours training, $560. 4.5 hours treatment, $630. $560, $420, $560, $560. Now, those are small amounts, but they add up over 4 years, and you're billing these multiple bills, multiple claims every day. Now, another count, 9 and 10, is money laundering. They then got criminally derived property over $10,000 and sent it via wire transfer. So Hanan Yusuf dropped 30 G's in 21. She's like, man, I'm flush. To a real estate company, number one. Then Shamso sent a personal bank account in a money order or something for $11,000 to a money transmitting company back over to Kenya. That money is gonzo. So they say every single dollar should be forfeited. How are you going to get it? It's in Kenya. It's gone. And we got ripped off for $21 million because these two came over here and they decided that we're all idiots and yuppies and we can just pay for their lifestyle and their Kenyan real estate. So all that went down, and both women are citizens, and Hassan has been naturalized. So at least as to her, she should be denaturalized and deported. The other woman apparently was born here or something. And so she's a real American who is sending money back to Kenya. Great. So, of course, whole thing is ridiculous. And I hope they get the absolute maximum. This is taking place in the District of Minnesota. We'll see what the judge does ultimately, whether they take a plea deal or what. But Homeland is on it. And as we saw in Minnesota, we've got more Americans, so-called, who are doing the same thing in Minnesota, committing an insurgency and an insurrection in Newark, New Jersey, outside Delaney Hall. And our friend Nick Sorter, I believe, is on scene sharing these videos. And I'm not going to play this one because this dude is swearing all over the place. But this rioter says, "I have your face, MFer," to an ICE agent, to somebody, a federal agent at the facility. "Your whole effing family is dead," is what he says. Okay, that's a threat. Your kids, your wife, all of them, I'm going to eliminate. This is the type of terrorism that they want ICE agents to face. They want to demask them. And the person who is saying these things, you can see, is right here on camera. They're all just, flagrant and shameless about this. So this is the scene out of a federal facility. Nick Sorter, somebody's recording it out there. I see his watermark and nobody else's, so I presume it's him. But this is the dude screaming at them, "I'm going to take out your whole family," whatever. Won't play the clip because it's, violent. But they are making some arrests. And it has been multiple day onslaught, attack, and obstruction. And of course, it needs to be stopped. And I don't know why it has not been stopped. I don't know what they're doing out there, but they're essentially enabling it. Maybe they want it to get worse so that it can be used as an explanation for who they are and what their party stands for. But to me, it feels like it's just encouraging more of this lawless behavior and preventing the deportations from happening with haste, which they need to do. So here was another situation, once again from Nick Sorter, and they're literally chanting, okay, "You will hang." And that is going over to this guy who may or may not be an African American. So here's what they sound like. Okay, that's the peaceful, loving, save planet Earth, we have to stop climate change, Democrat constituency right there. They want federal agents to die, and they want illegal aliens who break the law and who, like we saw in New York, apparently abuse 14-year-old boys to be set free, and the entire immigration system to be destroyed. So Mark Wayne Mullen is out. And he talked about some mechanisms of responding to this. And he said, we're just going to stop sending flights into these sanctuary cities. And I think that's a good place to start. Here's what Mark Wayne Mullen had to say in this exchange over on Fox.
When we have situations, what's happening in New Jersey right now, when we have to prioritize where we put federal employees because local law enforcement won't help protect their streets, not federal streets, city streets, and keep them from barricading and causing harm to our employees, then we have to decide where we're going to prioritize our federal employees. So we're not going to halt the flights. What we're saying is we just won't be able to process them because we don't have officers there. We're having to pull out our Customs and Border Patrol officers that process these flights and put them in these facilities to help protect our employees coming out of work. That, by the way, and that's not their job. Their job is to do just what they said, Customs and Border Protection. However, since local law enforcement isn't able to do their job because they said, quote, they don't have the resources, well, we have to prioritize our resources as well. And if they're not there processing international flights, then those individuals, when the airlines land, they won't be permitted into the United States. When we have...
All right, that's one way to do it. So I think there should be some really significant penalties for the sanctuary cities. They're in open, flagrant violation of American law, and they're enabling this type of behavior in places like New Jersey, Minneapolis, LA. Anytime the feds try to come in and just create some integrity around the population of America, it is a full-blown insurgency that springs up. And in many ways, they are winning. We saw what happened in Minneapolis and Minnesota. And so closing the floodgates into the sanctuary international airports would be a good place to start. And hopefully they do it we're going to keep our eye on this one. And the DOJ and the FBI and Homeland are continuing to make arrests. And so Shamzo and Hanan, we'll see what kind of penalty they get. Maybe a sentencing judge will actually give them an appropriate sentence, but maybe not. Maybe the amount of money they made and shipped overseas is worth every penny. We'll have to wait and see. We've got this case marked down to follow. Thank you for joining us as we continue to keep our eye on all of the fraudsters and hopefully many more arrests to come. All right, friends. Now, if you're just getting here, quick recap. It has been a lovely stream. We talked about big news over in the election executive order case. Lots of election updates today, actually. So we read through this one from Judge Carroll Nichols. The Democrats, the NAACP, the Latinxos, they all sued. They said that we don't want Trump to even think about implementing this executive order. The judge said, you don't have any standing. You've suffered no harm. And it is time for your lawsuit to be denied. And the injunction was rejected. So big win and a nice one. California, they are now responding, invoking Louisiana versus Calais to say that California's racist maps have to go. We also saw the Congress is now investigating the extra 565,000 ballots that were shipped out in Maryland, where they say there's no election problems at all. Congress is looking into that one. We also had a new filing and a brief from the DOJ saying states can and really must eliminate non-citizens from their voter rolls because they should have never been on there in the first place. And then we heard from Harmeet Dillon. Then we turned our attention over to E. Jean Carroll, and we saw that she's now under criminal investigation. There's some idea that she is a liar and lied about the man who is funding her lawsuit, this guy called Reid Hoffman, who presumably spent hundreds of thousands, if not millions of dollars on that case. They lied about it. They covered it up. Then they revealed it 2 weeks before trial. The judge said, not a big deal at all. Who cares? And E. Jean probably knew about it and was not honest about it. So we saw that. They're also investigating Alvin Bragg out of Congress and the New York fraudsters as well. And we saw Scott Bessent was here talking about the new weaponization fund, anti-weaponization fund that will be paying out, hopefully, to right the remedies of the past. Then we talked about these two who just got criminally charged for $21 million in stolen funds. Much of that money flew overseas. And of course, the ICE attacks continue on in Newark. And it almost feels like a brand new summer of love, doesn't it? Fiery, but mostly peaceful. Right back in time for the election. Great. All right. So now, my friends, let us hear from you. And thank you for subscribing to our channel if you haven't already done that. We would love to see you back here tomorrow. We go live every day during the week. We have a beautiful members only community as well over on YouTube. You can join. Just click the join button if you're watching on YouTube. Come over to watchingthewatchers.locals.com if you're looking for a different platform to come connect with us. And we'll see you tomorrow morning on the members only morning stream. Dun, 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 dun. Hey, what's going on here? Couple of comments. Trump said her cat was named Vagina. It's true. It's what she named her cat. Whole thing is really whacked out. Hey, Viva Las Vegas and Viva Fry. Welcome to the show, Viva friends. Great to see you, Viva. Hopefully, Viva's community is enjoying the show. We love Viva. He's right next door on YouTube and on Rumble. Thank you, Viva, for the raid. And hopefully you had a great stream today. Hey, Winning Reality. What's up, Winning Reality? Glad you became a member. We covered all the Supreme Court decisions. 4 Supreme Court decisions dropped this morning. We covered those on the members only stream this morning. So if you're a new member or you become a new member, check those out. We hit the highlights on all 4 of them. 3 criminal cases, 1 arbitration case, which was not that interesting. But there was one that was pretty close. It was a 5-4 decision. Roberts and Kavanaugh joined with the libs about racism and about whether a jury had, the right colored people on there. And they said it didn't or may not have. So Probably going to have a new trial on that one. But we talked about it all this morning. If you remember, check it out. We had a good one. Off-label pot, and we got to unpack the decisions together in real time, which is always fun. So off-label, I knew it. All this election info and court fights happen right before the midterms to cause problems. This election will be questioned heavily too. Yeah, that's exactly right. Yeah, I mean, I think they all are anyways, but we'll see what happens, man. And if it's going to be very curious if the Republicans keep both the House and the Senate. You can imagine the left is just going to have a election meltdown. Off-label podcast right next door. Check out the channel and have a great stream. Hey, Great Eagle One said online paid to shop CA coming to USA. Hear all from Great Eagle One. Man, thank you, Great Eagle One. We appreciate you. Thank you for the dono. King of Biltong is here. Are you craving a snack that's bold, authentic, and packed with protein? Well, Biltong boasts over 50% protein, packed with B vitamins, creatine, iron, zinc, and more. You can go to Biltong USA, and you could use code VIVA for 10% off. Or you can use code Robert. Use either one. I don't care. We love Viva. You can use his code too. At least it's the same. 10% for Viva. He better not be getting a better deal than we are there, Biltong boy. Hey, what's up, Cliff Beggs? Many blue states are threatening the companies that are fleeing. Kathy Hochul, a New York City mayor, would do well this weekend to read the novel by Ayn Rand, Atlas Shrugged. You know who else is doing that? China. Yeah. I saw a bunch of capital controls got imposed. And yeah, it sounds about right. So Rand posed the question, what happens when wealth creators leave and the remaining citizens are left with only the moochers and the looters? New York City and New York are living the novel now. Seattle is on their way too, with pampered young lady masquerading as mayor, saying Starbucks is gone and more to come. Yeah, and I think in some way they're kind of okay with that. It's almost like a great filter. Like they want the less productive people to go and leave so they can have more of a supplicant, compliant population that is reliant on a government. It's like a filter. That's why they give people certain privileges and attack others. It causes a demographic shift. And, you know, if you have people who are questioning your government, that's difficult to your continual power. So get rid of them. Who cares? Starbucks leaves. That's great. You don't have to listen to them. They have no more influence. You don't want the big corporations. You don't want the millionaires, the billionaires, because they have influence. So get rid of them. Then you can control the whole thing. Hey, Biltong. Hey, okay. Use code Robert too. That works too. Thank you, King of Biltong. No problem, my man. It's hilarious. We love Viva. At least it's not like use code Rachel Maddow or something. Be like, what is going on over there? You know, that'd be a problem, but it's not. We love Viva. Hey, Will Crump, what's up? In California, Nick Shirley Act is now law. I saw that they were getting close to passing that. Is that now officially signed? Wow. So that's just what they do. If you investigate them, you're the criminal now. It's not about the criminals. It's about the people investigating the criminals. They're the real criminals. Thank you, friends, for those amazing donos and for sending those in. It has been a lovely stream. Let's see what else we got percolating over on X and on LZ says, what? Pfft, tell me about it, man. I don't know. LZ, you're right. Who the heck knows? Yeah, so it passed. Did Newsy sign it into law? Is that right? Hey, Walk It Off says, per Atlas Shrugged, yes, it's great until infrastructure is paralyzed. Yeah. Rick D, hey, speaking of illegals who commit crimes, Walls called an emergency session of the Pardons Board just to pardon an illegal who committed felonies and was scheduled to be departed, so the convictions couldn't be used for deportation. Of course. Yeah. Think that would ever happen to you or your loved one as a citizen? Like instant emergency pardon? Get everyone to get. No, they would never do that. Because we're just peasants here. We're the subclass now to the foreign invaders. Walk It Off. She has never exclaimed any harm. So where's the harm? Well, I mean, you're talking about E. Jean. I think she has. She's, it's like traumatizing, and she had to name her cat Vagina, all these things. Maybe that's why she's so weird. That might be her allegation. And hey, what's up, Rick D? Mitch McConnell just voted yes to move forward with the SAVE Act, supposedly. I thought all senators were out of town except for pro forma sessions. Yeah, pretty sure that's right. I think they're all gone. We checked the committee schedule on Monday on the member stream, but let's check it again right now. I don't know what they voted on. This is the congressional schedule. So I didn't see that if it happened, but that also may just be performative from Mitch McConnell. They need to end the filibuster in order to pass that, because they're not going to get past the filibuster. What's up, Rick D? Thank you for that. Amy Ann, there might be something with the old Russia after all. Apparently, Melania opened 3 different bank accounts in 2017, which got $127 million that she failed to report from Russia. From Amy Ann. I didn't see that story. It's always Russia. The likelihood of that, I think it's probably came from John Brennan or something. Anyways, thank you for that, Amy Ann. We'll keep our eye out for that one. Let's see what else we got over on X. See if we got any comments over here. We do. Dun, 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 dun. Neuro D, thank you for linking up over to our watchingthewatchers.locals.com community. It is a beautiful day. And Mike Hess. What the heck is this one? It's Tucker and E. Jean Carroll. I don't know what's going on over here, but that's a little disturbing. Okay, so she's just crazy. All right, what movie is that from? Yeah, that's John Candy. What movie? Hey, Darby Shaw. Unlike Medicare and private insurance, Medicaid doesn't send out EOMBs. Some Medicaid programs have the claim info on the program site, but you have to look deep for it. Parents who are alert would catch fraudulent claims if they got a hard copy from Medicaid. Well, I think, don't they know they're in the fraud? Look, my kid doesn't have autism. Yes, he does. Okay, I guess he does. You're the doctor. Sean Hansen, what's up? Fantastic wins. Yeah, some good stuff today. Thank you, Sean. And what's up? Hey, B. Torn, look who showed up in Newark. Yeah, Greg Bovino's back. Man, he wasn't playing around the last time he was there. He's going out there. Shout out, Greg. Go clean that place up. And B. Torn, it wasn't all violent. It was clownish, too. Somebody got dropped by a taser out there. And man, thanks for checking us out over on X. We also post our stuff over there. And it has been a lovely and a beautiful stream. Hey, what's going on? Yeah, LZ says, what? Yeah, here's a chronological list of pro forma sessions. Yeah, Hawley just gavelled in, right? Hawley just gavelled in May 26th. Ernst was May 22nd. Cotton, then they were in session. Then they're gaveling in. They'll gavel in tomorrow, probably, pretty sure. Let's check on C-SPAN. Did they gavel in today? Oh, yeah, they did. Yeah, so, yeah, they did today. Right here, boom. Senate pro forma session today. Every 3 days or so, they gavel in, and the House pro forma session's coming tomorrow. So just get ready for that one. Because they don't want any recess appointments, because they hate us, I guess. So, all right, friends. It has been a beautiful day. Hey, Veni Vidi Vici, what's going on? Welcome aboard. I came, I saw, I conquered, right? Good to see you. Veni Vidi Vici in the house. Welcome aboard, our newest supporter. Thank you for signing up and supporting our work. We had a great members only stream this morning. We talked all Supreme Court stuff, and then we talked about Harambe, moment of silence for Harambe today. Thank you. And we talked about the bull in Bangladesh, the Trump bull, who's going to survive. Whew, that was close. So we had a good, fun stream on our members stream this morning. We'll be back tomorrow for our members only stream as well in the morning, 10 a.m. Eastern, if you care to join. Otherwise, we'll be back in the afternoon to get into it again, and we'll have even more good business to attend to as we close out the week. But we'll pause here on the night. Want to thank our amazing mods and meme smiths. So much thanks. Go out to Muffin Rando, to John in the house. We got Donut Mind Me. We have K Bean and Carrie B. We got Neuro D out there, Janek and Dog Digger over on the Rumbles. Geegum Geegum, Elliot, just Rhonda, who made all those very nice emojis in the chat. And my friends, thank you for being here. Thank you for subscribing. Thanks for liking the video on your way out. Thanks for inviting a friend or family member to come on and join us tomorrow, so that we can share all this good news with them and have some fun. But we'll pause here for the night. I hope your evening is beautiful, your rest is outstanding, and you awaken bursting full of energy. And you come back here tomorrow, because in order to do this appropriately, we are going to need to see you right back here, so that together, with your help, we can shine that big, beautiful spotlight of accountability and transparency down upon our system, with the hope of finding justice. Make it a beautiful night. Sleep very well. We'll see you right back here tomorrow. Bye-bye.
Thanks for watching, my beautiful friends. Now it's that time where the stream must end. You brought the heat with every chat and line. Together we expose corruption. One more time we dove in the truth where the media hides. Lit up the lies with receipts on all sides. The fight isn't over, but we made them sweat. We ain't done yet, no, not just yet. Because together we are watching the watchers. Truth on our side. Watching the watchers. We won't be denied. Watching the watchers. Eyes open wide. Fighting for freedom with nothing to hide. Drop a like and don't forget to share. And bring a friend who's ready to care. Tomorrow's lies are just today's news, but